this court had to witness not just crying and giving testimony, but her mom sitting right there crying and listening to her daughter relive that horrendous experience. All right, good morning, everyone. We're on the record on the Fessler matter, case number D23. D, may I have appearances, please?
Good morning, Your Honor. Lisa Szyc, 11726, appearing on behalf of who I believe is appearing by Zoom. She couldn't get off work today to be here.
Not a problem. Thank you. Good morning. I do see her present. Miss, I believe is what she goes by, right?
Yes.
Okay, Miss. Okay, thank you and good morning.
Good morning, Your Honor. Molly Rosenblum, Barnaby, to court on behalf of the defendant. He's present.
Thank you and good morning. And I see we also have the grandparents present. Good morning, sir and ma'am. Mr. and Mrs. have you here as well. And good morning, ma'am. What's your name?
Diana.
Thank you. Okay, and your relationship to the parties? Oh, yes. Okay, thank you. And I believe we have Ms. Dory with ONJ present as well. Is that correct, ma'am? Okay, thank you. Okay, good morning, everyone. We are here for defendants. I'm sorry, this is plaintiff's motion as well as defendant's opposition there too. I have reviewed the papers and pleadings. Has there been any resolution?
No, Your Honor.
Okay, not a problem. I'm familiar with this case. I'll give you guys, you know how we do it, 5 minutes apiece. Don't interrupt one another and don't interrupt me. When you're speaking, do stand.
Thank you, Your Honor.
You're welcome.
Your Honor, pursuant to NRCP 60B2, we believe that there is newly discovered evidence by the way of Mr. complaint, specifically on page 3, paragraph 9, Mr. is that on October 9th, 2022, third-party defendant, which is knew or should have known of the risk to plaintiff, which in that case was safety, including that third-party plaintiff history of sexual addiction, plaintiff vulnerabilities as a minor with a history of consuming alcohol and drugs, both with and without third-party defendant. Later in the complaint, Mr. argues that should have known that the danger that she did not stop that danger. Further, later in the third-party complaint, alleges that negligent, reckless, and that her actions and omission directly and can approximately contributed to the conditions that led to alleged harm. Based on NRCP 11B, this is assigned pleading and allowed to infer that the representations in the third-party complaint are factual contentions based on evidentiary support or will likely have evidentiary support. And this is not information that was known at the time of the trial. So we believe that we have met our threshold under NRCP 60B and that the motion is righteous. With that, essentially, in the third-party complaint has admitted that he's a danger and that need to protect. Therefore, it is not that far of a leap to if to one child, she has the same duty to. So if danger to not that far to say that he would be a duty to with this sexual proclivity and the use of drugs and alcohol. So we think, although this was heavily litigated before Your Honor, this admission wasn't made at the time of trial, and we just wanted to bring it before Your Honor's attention because now we have a direct admission that's being made by way of the third-party complaint. So I do believe that we have met the threshold that this is a specific admission that's being made and something for the court to consider. Specifically with respect to child support, I believe that we'd ask the court to reconsider the position with the decree for the child support between May and November. There was no child support being paid at that time. There were also no alimony or spousal support payments being paid at that time. And under NRS 125B.020, a parent has a financial obligation to support their child. So we would ask the court to reconsider the position with respect to the child support payments, since there was no financial support during that time at all. There was no stipulation between the parties. There was no order for financial support during that time. I do believe that based on the statute, financial obligation to support and that child support should be set at the amount that was in place prior to the decree for those months, since no order had been set at that time for the months of, and I will note, I believe I stated it incorrectly in my motion, the last alimony payment that was made on May 1st. So I do want the court to take that into consideration.
That was per the agreement of the parties.
That is correct.
Correct.
The last alimony payment was made on May 1st, and then after that, there were no financial payments made, either alimony or child support, until the decree was entered.
Okay, thank you.
And then, well, the one last thing with respect to child support, the decree noted that not meet an obligation for imputed income. And so the decree was set at amount per the financial disclosure form. However, I would point out to the court that NAC 425 states that the order must be based upon the obligor's earnings, income, and other ability to pay. And the court did make a finding about ability to pay. Specifically, the court found on, in paragraph 200 on page 41, the court did make a finding about ability to pay. Specifically, the court found in that paragraph that when working full-time at his hourly rate, gross monthly income is $9,600, almost twice the amount in which child support was set at. So I do believe, based on that court's founding, did satisfy that requirement, and I don't think the standard is imputed income based on NAC 425-100. It's the gross income or other evidence of ability to pay. So under the NAC 425-100, I think the court can set child support at the $9,600 because the finding was made that when he's working full time, that is the ability he has to earn, and I would submit it on that.
Okay, thank you. Okay, let's go ahead and go. Next person, Ms. Rosenblum, go ahead.
Unless the court.
Go ahead.
Are you sure?
Yes, well, I'll save my comments for after I hear from both parties. I apologize.
So, Your Honor, I know this court reads everything and is very familiar with this case because it's been practically litigated to death. So I'll keep my comments brief. Specifically, my client's request for relief today is to deny the motion in its entirety for two reasons. Number one, there's no financial disclosure form filed by Ms. She has not filed a financial disclosure form for the last 2 years. It's been over 2 years since she has filed an FDF. And as this court is well aware, Rule 5.507 specifically states a general financial disclosure form must be filed in support of any motion or counter motion that includes a request to establish or modify support, child support, spousal support, fees and allowances, exclusive possession of a residence, or any matter involving money to be paid by a party. Her failure to file a financial disclosure form in support of this motion should be construed as an admission that her request for monetary relief has no basis at all, period, end of sentence. This argument under Rule 60B2 is, I don't know how else to say it, Your Honor, other than total garbage. The idea that they didn't know or weren't aware of the incident of admissions made in both a criminal matter, the statements that he made on the witness stand, etc., could have been explored, should have been explored, was explored in 2 days of trial. And the fact that they're standing here today saying, well, we didn't know, and that should be a basis for us to undo all of this litigation and relitigate this entire case, it's stunning that in good faith we're standing here making that argument. The complaint in and of itself does not make an admission that he is a danger, period. That's their inference. And this can be litigated in the civil case, which they have filed and, by the way, failed to answer. So they're now technically in default of his third-party complaint. And in fact, have actually taken no action in their civil matter. But these are arguments for the civil court. This court has heard argument after argument after argument after argument in this case, litigated extensively, 2 days of trial, and to now come back before the court and state that Your Honor's 80-page, I believe, decision that is down to the detail should somehow be set aside and undone because Ms. didn't know or couldn't have known. It just lacks all credibility whatsoever. The court made a decision. It seems like the other side wants another bite at the apple. They want to perpetuate litigation and keep this thing going. I think we can all speculate as to why. But at the end of the day, these parties need finality. They need certainty. They need to move forward in their lives. If Ms. file a financial disclosure form and have a conversation with us about a modification of child support, we would be open to that conversation. But to continue to just file motion after motion after motion, it is bankrupting my client. And that's their plan, Your Honor. Quite frankly, that's the plan. They just want to litigate him to death. She's got a free attorney, and it's just paper him to death until he cries uncle. He's willing to talk about child support, but the rules aren't different for her. They're not different. She's required to file an FDF. She hasn't done it. And on that, Your Honor, I'll submit it.
Okay, so Ms. Rosenblum, has your client, or I actually, when I swear in the parties, I like to always talk to the parties unless there's no criminal matter that precludes Mr. Right?
Correct.
Okay, excellent. So of course, with council's permission, ma'am and sir, please stand and raise your right hand. Let's swear you in.
You and each of you do solemnly swear the testimony you're about to give in this section shall be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, ma'am.
Thank you.
Yes, Your Honor.
Okay, thank you. All right, I'll have Mr. already standing. So Mr. I understand, this is the first time I've heard that you didn't pay child support from May through November. Is that true, sir?
Your Honor, we discussed out in the hallway financials that nothing was brought up, nothing was paid, nothing was told to be paid. I take care of my son when he's with me. Texted me and said I need help with child support or anything. There was no order to pay child support. We were waiting for the order, which was supposed to be done, I believe, 30 to 45 days after May 2nd. It was just.
So the standing orders of the court to pay child support is because it was couched as family support. So I'm trying to understand, because I know that there were standing orders prior to when you guys came in to do the bifurcation. We had standing orders, and maybe Ms. Rosenblum, you can answer my question better. We had standing orders for him to pay child support. I never ceased child support. So I was surprised to hear that he didn't pay. That was not brought up at trial at all. And I guess that's why me reading this is the first time.
So, Your Honor, in terms of the child support itself, my understanding is that there was an agreement on all of the financial related issues with regard to the house, the alimony, the debts, etc.
Right.
I believe that there was never an actual child support amount set.
Okay.
And so therefore my client didn't know what the court's order was
Okay.
going to be, and so therefore didn't pay. I don't think there's an argument that there's probably some money owed based on the court's order, because child support is child support. We all
Absolutely.
know that as practitioners.
Yeah.
And I'm happy to have that conversation
Okay.
with Mr. I don't think that's really up for
Okay.
debate. I think it's just
Sure.
there was some confusion about what the number was that he
Okay,
was supposed to be paying.
makes sense. Okay, understood. So dad's not trying to avoid child support.
No, not
There's
at all.
just wait for some clarity on what the amount is, and then he'll pay that. Okay, all right, thank you. And now next thing is Mr. I thank you for filing your FDF, Ms. Rosenblum. Thank you for filing that. So Mr. See that now your income has changed from when you were at trial. The FDF that you filed from trial to date. Can you explain that to me?
Yes, Your Honor. I submitted a picture. It was a little late because they don't update every month. They update every month on the 15th. But every month last year, I took every single call that got to me. Everyone. I got on a single job, which was a powerhouse shutdown for NV Energy. It was a 31-day job, 7 days a week, 14 hours a day. I made $32,000 on that one job. That was my major income last year. October 9th of 2024 was when I went back to full-time work.
Okay,
Other than that, I was taking short calls. I was taking every single call that got to me. Not one has slipped through. And I did submit all that paperwork for trial that you have seen.
Mhm.
Every call that I could have taken, I took.
all right, so your new FDF that was filed on 1/31/2025 reflects that your new total average income received is about $83.95, and that basically breaks down to you have some overtime at 1503, you have your regular hour at 68.91, year to date was 63.61, and adding those two brings you to about 83.95. Is that still accurate?
Yes, Your Honor.
Okay,
Same.
so I know it's been a few weeks since then, but it's still pretty much 83.95. Okay, and that dates back to October when you took that job.
Yes, ma'am. October 9th.
Okay, prior to October 9th, I know we had trial and the time frame of this was we had our evidentiary hearing, a 2-day evidentiary hearing, April and May. And then mom filed an appeal, which divested this court of jurisdiction. This court was waiting for the appeal to either render a decision or whatnot. And once the appeal was dismissed, that mom filed, I believe it was November 22, it was dismissed. Within 4 days, the court entered its custodial orders at that time. So during that time, your income was the income that the court was basing it on was either 1, your testimony, or 2, your FDF. But your income did increase as of October when you took that job with Nevada Energy and made about 32,000. You didn't file an updated FDF at that time though?
Your Honor, if I may correct you,
Mhm.
the job for NV Energy was in the summer. I currently work for a company called Conti.
Okay,
I just wanted to clarify that.
okay.
That
all right.
NV Energy job was a one-time thing. They don't do powerhouse shutdowns very often.
Sure, okay. And so you made that 32,000 in October, right?
I would say July-ish.
Oh, July?
Yes.
Okay. You didn't file an updated FDF to reflect that increased income?
Your Honor, so he's union
Yes, ma'am.
electrician, so jobs and then no jobs, jobs and then
Sure,
no jobs.
yeah.
And so my experience with the union
Right.
is that we usually we're looking at a 12-month average because there's periods of unemployment and then periods of employment.
Okay.
And so I would, in my practice, would tell him at the earliest 12 months
Okay.
of pay, because that can go
Okay,
up and down pretty much every month. So if
Mhm.
he's filing FDFs every time he takes a job or loses a job, I mean, we're gonna paper you to death with FDFs, so.
okay.
I would expect,
used to
so my
it.
understanding, this particular job
Mhm.
hopefully will be for the year, and I would counsel Mr. at the end of the year to file that updated FDF and provide his tax information to Mr. so that they could try to resolve this issue amongst themselves, which is what he feels like should have happened in this
Sure.
case. He's not saying he wouldn't agree to pay more or shouldn't pay more. He would. It should have been a conversation between the two of them.
Okay. All right. Has he provided his taxes already to her?
I have not filed taxes.
Not yet. Oh,
We have-
okay.
yeah.
All right. Okay. All right. Thank you, sir. Okay. So- And now, Mrs. Tell me about your financial situation. I don't see that you filed an FDF with
I
me.
did not, and that is my fault, and I apologize, Your Honor. I'll get one in as soon as possible.
Okay.
Your
That's
Honor,
my fault.
I believe that there's been no change since the testimony that was noted in the findings in the November decree.
Okay, so if there's been no change, and counsel, you should know this, then you should have in your moving papers a statement that simply says there's been no material change for the last 6 months, but it hasn't been 6 months. So Mrs. Financial situation currently.
I am an intern at Clyde Jubel, and I make $20 an hour, and I work 20 hours a week.
Okay. So congratulations with your internship. I know this is a head and a step in the right direction towards your degree. Is that
Yes.
correct? For
Yes.
architect?
Yes, thank you, Your
All
Honor.
right. You're welcome. Well, that's good. I'm glad to hear that you're in your internship, making $20 an hour, working 20 hours a week. What are you doing with the rest of the time? Have you picked up a job on the other half for the rest of the time?
She's still in school.
No, I'm still full-time in school, Your Honor,
Okay. When are you expected to graduate?
in May.
Okay. So it's coming up.
Yes, and I expect Clyde Jubel to keep me on and go full-time in May.
Oh, congratulations. Did you get an offer of employment already?
Not yet.
That's what you're hoping for?
Yes,
Okay. And that's why you're continuing your internship and in school?
yes.
Okay. All right. And how's
He's doing very well. He's doing good in school. They just got back from Disney World and he had a blast. So he's doing very well.
okay, good. I'm glad to hear that. Okay. Anything else you want to let me know?
Just that I need more help financially. For the past year, I mean, while I had no financial support, I was living off student loans and part-time work and scholarships. I was using a lot of that money to live on, but it's gotten to the point where I've spent them. I've spent the student loans, the scholarship money it's spent on rent and thing, and I'm to the point where I need help. I need a little more help.
Okay. All right, thank you, ma'am. And that's why, counsel, you should be filing a financial disclosure form, because if your client is seeking financial relief, then the rules are very clear. A general financial disclosure form must be filed in support of any motion or counter motion that includes a request to establish or modify child support, spousal support, fees, allowances, exclusive possession of a residence, or any matter involving money to be paid by a party. I have utmost I'm very familiar with this case. We had a 2-day evidentiary hearing. Extensive findings of fact were rendered. The court was prepared to render a decision earlier, were it not for the appeal that divested this court of jurisdiction. So, of course, in order to remove any appearance of impropriety, this court did not even render a decision or take any action until the Supreme Court made a decision on the pending appeal that Ms. Szyc filed. Once your appeal was dismissed, this court rendered a decision, I believe, within 4 days of that. And my custodial decision was very much in mom's favor. I don't know if I need to read some of these findings of fact again, but I don't see anywhere in here where it was really in dad's favor. There are findings, extensive findings here that were made in mom's favor to give mom the custody that she was seeking for. This court heard testimony from herself where offered gut-wrenching testimony regarding the abuse that she suffered at the hands of Mr. in the home. This court had to witness not just crying and giving testimony, but her mom sitting right there crying and listening to her daughter relive that horrendous experience. So for you to file a motion to try to reopen this case based on newly discovered evidence, which is essentially a third-party complaint, and all it is at this point is a complaint. It's allegations that are made. It's a complaint that has nothing to do with who is the case in point here, who I have to focus on. I have heard utmost upfront, close, and personal testimony from the victim herself. There is really nothing that this third-party complaint can offer that's not going to change my decision to ensure that mom has full custody of this child. Unless you don't want mom to have full custody and you want mom to have joint custody, because I know dad is jumping at the seams to get joint custody. That's what he's argued for. That's what he's asked for throughout the pendency of the proceedings prior to trial. There were stipulations. Mom's counsel was first Mr. Schneider, then Ms. Szyc. But Mr. Schneider actually was the one that came in here and had stipulations to giving dad the weekends. First, this court in the utmost caution for the safety of the child, considering the criminal case that dad had pending. And of course, considering dad's rights, we didn't want dad to have to say anything that could disparage him in the criminal case. This court put some very strict supervision orders in place. But once that was lifted, mom's attorney through Mr. Schneider actually was in agreement with it. And dad had his weekend visits. Mom had, I think she wanted her third weekend. So we made sure mom had her third weekend. I actually asked mom, which one does she want? Mom voiced her concerns about the guns. So we made sure that the guns were nowhere in sight. But this court gave mom plenty of opportunities and, was very gracious to hear from mom, and took mom's testimony to light at the evidentiary hearing. I rendered 71 pages of detailed findings of fact, conclusions of law, where I found mom highly credible and compelling. And I found dad lacking in credibility, remorseful. I did find that he did present probably the most credible testimony was when he took accountability for something. But even that did not sway this court in giving him a scintilla of having joint custody. Mom had custody, and I found that mom established not just in the best interest factors, that it's in the best interest of the child for mom to have custody, but I also found that mom established clear and convincingly with the clear and convincing evidence, which is 125C0035 subsection 5. So I found subsection 4, best interest factors in mom's favor. I found subsection 5, best the domestic violence rebuttable presumption in mom's favor. I don't know how much more detailed I can get to find in your client's favor as it pertains to the safety and protection of this child and ensuring that dad's timeshare was limited to the weekends. He had weekends during the pendency of the case. I gave him the weekends. I actually scaled it back because I believe during the pendency of the case, he had weekends and any off days. So for example, if there was a weekend and a holiday or a staff development day, he would get that as well. But after hearing all the evidence and reviewing everything, I scaled it back to giving dad solely the first, third, and fifth weekend. First, second, and fifth, or first, second, and fourth weekend. I have it in here, and I gave mom the third and fifth weekends. I am not going to grant your motion to reopen this case based on what you're claiming is newly discovered evidence, when I heard very clearly up close and personal the best evidence, which is hearing from the victim herself and hearing from the parties themselves. If you want to drag this out with further litigation, then you can do that in the third party complaint, which is where it belongs. But as far as custody is concerned for this child, this court finds that I heard the best evidence, which was the evidence of this victim, as well as the evidence from the mother and father in this case. So based upon my review of the motion, and when you're filing a motion to set aside, you must establish all the Yoakum factors. I didn't see that the Yoakum factors were specifically pled or addressed, but I do, in the interest of time, find that basically, while there was an application to remove the judgment, my decision was rendered on 11/26/2024. We are still within the 6-month time frame, so it is timely. The absence of intent to delay proceedings, the court does not find that there was any intent by mom to delay proceedings. The court does find, though, that there may be some intent to try to extend and prolong proceedings, and cause some duplicative proceedings when this court has already rendered a very clear ruling in mom's favor for custody, with some very detailed findings, finding mom credibly establishing not just the domestic violence vis-a-vis, but the domestic violence that mom had to endure in the relationship with power and control and rage issues. The lack of knowledge of procedural requirements does not apply. It's questionable about whether it's a good faith application, but I'm going to give the parties the benefit of the doubt and find that there was a good faith effort, but I don't find that there is a meritorious defense or meritorious claim, considering that the policy, of course, is to resolve cases, especially custody cases, and this court heard the best evidence, which was evidence from the victim herself, as well as having the opportunity to review both parties' demeanor, body language, behavior, and their testimony in the 2 days of trial concerning custody. With regard to the second issue, with regard to child support, now I cite to EDCR 5.507 because that's not a ambitional rule. It is a mandatory court rule. And this is not the first time that Ms. Szyc, maybe it was prior counsel, so it might have been prior counsel and not you, I don't know. But if you're filing a motion seeking financial relief, I read the rule out loud. It's very clear that a financial disclosure must be filed. If there has been no change for the past 6 months, I have been lenient. And if the party said there's been no change, everything is exactly the same, counsel, you should have at least had a statement that says there's been no material change, but that's not the case here. Your client just testified to me that she is bleeding. She has no money, and there has been a change where she's now doesn't have money. So with that said, it's absolutely incumbent as counsel to file a financial disclosure form so that you can establish, one, maybe her income is less and her expenses are out the door. She's had to take up more loans. She doesn't have money. But at this point, you haven't even done that.
Your Honor, if I may,
Sure.
I wasn't sure if that would be required on a motion for reconsideration, because I wasn't essentially seeking new financial relief. I was asking you to reconsider relief that was ordered from the decree.
Okay.
So that is why that wasn't done, because I wasn't putting a new issue in front of you. I was asking you to reconsider relief that was already ordered.
Okay, but you're asking me to reconsider relief that pertains to financial relief to give
Sure.
your client more, to basically give your client more financial relief, which is here it says anything regarding financial relief. So
Understood.
I'll give you leave to file your FDF because your client is willing to. I don't think that your client is trying to be, deceitful or manipulative, nor do I think you are.
No,
But I have
and
to.
that was my misunderstanding, because I was essentially asking you to reconsider an order that you had
Sure.
already issued. So I didn't think that EDCR 5.057 applied, because this wasn't a new motion. It was like, I wasn't filing a motion for child support. I was filing a please reconsider an
Sure.
order you had already issued.
Okay,
I have to state on the record, that's just patently not accurate. The request is to increase his child support, so it's modification of the existing order, and it's for sergeant.
Mhm.
So it is seeking relief.
Which again,
An
No interrupting.
FDF should have been filed. I think the court has made itself clear. It's difficult to sit here and listen in good faith that they didn't know. This is not the first time, it's not the second time, it's not even the third time.
Mhm.
They have been told and for counsel to represent to the court that there's been no change. Her last financial disclosure form, and as the court noted, even Ms. it's changed, but her last financial disclosure form was February 12th, 2023, when this case was first opened. She doesn't reside in the same home. She indicates she has no income, which now she's saying she has income. She's saying she's
So there's been
taken
substantial
student loans.
changes.
There are significant
Mhm.
changes in her
Okay.
financial condition.
Thank you, counsel. And so,
Your Honor, if I may,
Mhm.
please. Again, to that comment, my motion was a motion for reconsideration under NRCP 60B. The issues that are raised in this motion are essentially the exact same issues that I raised in my appeal. So for counsel to say that I'm being disingenuous is actually not correct at all. Like, the issue that I put forth in this motion are essentially verbatim the issues that I put forth in my appeal. So again, I didn't consider EDCR 5.057 or 5.507 because essentially I put my appeal before Your Honor.
okay.
The issues that are here in this motion were the issues that I raised in my appeal.
Sure.
I'm asking.
But
you
it's
to
pertaining
reconsider-
to, do you think this applies or any matter, that's the last set of paragraph A, or any matter involving money to be paid by a party? Are you asking for money to be paid from Mr.? You asking me to order money to your client?
My understanding.
Yes or no?
Yes,
Okay.
Your Honor, yes, but I can, if I may, my understanding of EDCR 5.507 was when I was filing a motion asking you to issue a new order. I'm
Okay.
asking you to reconsider the order that you
Okay.
had already issued, the financial issues which were considered at trial.
Mhm.
So my thought process here was you'd heard the testimony from the trial.
Mhm.
I wasn't asking you to consider Mr. situation. I was asking you, nor were I was asking you to consider my client's new situation,
Okay.
because it is a primary physical custody case. I'm asking you to consider the decree on its face
Sure.
and reconsider your decree or
Okay.
position on the decree.
Thank
That
you.
is where I was coming from.
Okay, and looking at this though, I could do it two ways. I mean, if you're asking me to reconsider the issue in the case, I look back at the testimony and the vast majority of testimony, and rightfully so, went towards custody because that's the most important thing. Very minimal testimony on child support. And if you're asking me to impute income, and I've imputed income in several decisions, so I'm very familiar with 425 or 125 and all the factors in imputation of income. But it's not my job to impute the income. It's your job as the proponent of that to establish all the factors, or as many as you can, for imputation of income. But those weren't delineated. And when you're pointing to, and I'm going to go ahead and pull that up, because when you're pointing to my decision, page 41, when it was speaking about it, and maybe I should make sua sponte make that amendment here, because where did it go? Sorry, I had it flagged and all of a sudden it's gone.
It's paragraph 300.
Yes, no, I flagged it and pulled it aside, but now it got lost in all my papers. But I know what you're talking about. Page 41, that language, here it is. Page 41, the language at the very top, that's actually the testimony. So it should have said 199, testified he works for IBEW, testified he earns 53.83 an hour. When he works full time, he will earn this much. By 199 and 200 are basically, they should be prefaced with testified. That was testimony. So, and that's why you have the timestamp at the bottom. Those weren't necessarily the court making, when the court makes its official findings, it goes in and it has in big bold letters, the court finds and concludes that testimony was not credible. The court finds and concludes testimony was credible, etc. And that's where, my apologies, I should have added that. And if I need to right now, I can do that sua sponte, that on page 41, lines 4 through 7, number 199 should say testified that he works for IBEW Electrical Union as an electrician and has for 20 years. Timestamp is 202:16. Paragraph 200, line number 7 should say testified that he earns 53.83 an hour, pays 5,300 in union dues, and when for full time, he will gross $9,600 per month. That's just why there's a 109. And you can see that very clearly if you look at the timestamp. If you go to 109 and you look at 109, it says the footnote for 109 is 20600. If you go to 20600, it's not me speaking, it's the testimony of Mr. Then on 201, it said testified while he has never missed a call for work. So my mistake, that 199 and 200 should say testimony, because that's clearly what it was. That was his testimony. The court made its ultimate findings, though, based upon what it had in front of it, which was the FDF. Now, based upon the new testimony today that Mr. has started working and has increased income and has in fact been making more than the 56 that was imputed, or that was stated, it wasn't imputed to him, it was based on his FDF, there is definitely a basis for a modification of child support. I don't believe there's a basis or a need to reopen this whole case and relitigate this. That's the last thing I want to do, but I would absolutely be open to if you would like to file. I can't tell you what to do, counsel.
And based on that, I will.
But if you're seeking to file a motion to modify child support dating back to May or dating back to the trial, I am more than happy to do that. And we don't have to do an NRCP 60B motion for that. I want to make sure, and this is the beauty of, custody cases, it's fluid. I want to make sure that Ms. paid the
So
child support that's rightfully owed to her.
The motion that is in front of you was a motion for reconsideration on your decree. It was not a motion to modify child
I
support.
understand
And
that.
so if I need to file a separate motion
Yeah.
with the FDF, that is what I can do. But the relief that was before you
Sure.
today was a motion for reconsideration.
Understand.
So if you're gonna deny that, I will separately
Right.
file a motion to modify dating back to May.
Yeah, and that's
Yeah.
fine. And you can follow that, and I will give leave to go ahead and file a motion to modify dating back, especially considering the testimony that's been from both parties that there was no child support that was paid. It's not that Mr. wasn't, but this court needs to have made some child support findings
And
dating
then
back to
given
that.
that, since to not deplete or to have duplicative proceedings, I would ask then so that to keep costs down for both parties.
Yes.
If the court would then consider making a ruling on that motion without us having to come back on a hearing.
Absolutely,
Yeah.
absolutely. It's pace of.
Before a motion is filed, there be a 5.501
Yes,
conversation.
there
Because
absolutely
yes,
must be a
these all-
5.501 because counsel here, I mean, Ms. Rosenblum has already indicated they're inclined to do that. I
Yes.
think the next step is, why don't, now that we have this new FDF, she needs to file her FDF. File her FDF,
that's-
and then you can go ahead, have your 5.501, confer, meet and confer. I'm not gonna even look at a motion until you have conferred that you guys have talked about it. File the motion, I can hear it on the papers. I don't need another hearing or testimony. I've heard from Mr. Self and Mrs. Self, and I want to give child support based upon the most recent updated information that we have.
The only thing that I would ask is if, given that you did hear testimony and there is an issue with the order for the May through November, can I at least get a clear order on that today?
Yes, well,
on the
May
motion
through
for
November should have been
reconsideration?
at the what was based on his FDF at the time. So I think you actually had it absolutely correct. That child support should be set at least in the amount that was in place at the time. So looking at his FDF that was in place at the time, whatever the FDF was, based on the standard child support guidelines, child support from May through November should have been based on what was in place at the time. May through November, okay? And then now from November on, you can go ahead and have leave to file a motion to modify. Make sure you meet and confer first based on the new information that we have. But at this time, if you want to go ahead and prepare the order from today, motion to set aside is denied without prejudice.
Is it denied in part and granted in part as to the child support issue?
Well, as to the child support issue, what I'm gonna do, well, yes, what I'm gonna do for the child support issue, because it didn't address, and I looked back at the findings of fact, there was nothing in your closing brief regarding this. Had it been articulated, I definitely would have addressed it. I take your findings of fact, conclusions of law very seriously, and I look at what each of you guys both file. But we went back to look at that, and that was absolutely not pled or not addressed. That's why I'm looking at this, and this was the first time I saw that dad didn't pay child support from May through November. Had that been brought to my attention, I would not have allowed all this time to pass and dad not pay child support. But absolutely, granted in part to the extent that dad's child support from May through November should be granted at the amount that was already set by the court.
Well, so that, I think that's the issue, is that there was no amount set by the court, so use the amount in the decree for
Yeah.
May through November.
The amount in the decree from May through November,
Okay.
yes. And then November, you have leave to file a motion to modify dating back to that based on the new amounts that dad has testified to today.
Okay,
After you do a meet and confer,
yes,
okay?
of course.
But do file an FDF for your client.
Okay, yeah, and so
Okay.
just to be clear, this was not
I
a request
understand.
for new, this was just to
Okay.
reconsider the decree,
Understood.
so I
Understood.
want that to be absolutely clear, I was not asking for new relief, I was asking for
Okay.
reconsideration.
But I think in the interest of trying to give the relief that matches his increased income,
Yes,
it may be more beneficial to
and I'm
you.
sure Molly and I can work that out.
And Your
Sure.
Honor, I do have to ask on our counter motion for please, because again, this is multiple times. I appreciate the thought process, but at the end of the day, the rule is the rule.
Right, there was no meet and confer prior to this
There was
filing.
no meet and confer prior to this, and again, the child support issue could have been, in my
Mhm.
opinion, I think in my client's opinion, easily resolved. There is no financial disclosure form filed. again, this is multiple motions, multiple times.
And I would have to agree. I would have to agree. If there was that, there's a reason why we have EDCR 5.501, which requires the meet and confer. Now, Ms. Szyc, you can tell me as an officer of the court, did you meet and confer with Ms. Rosenblum or Ms. Tajbaj before filing this document?
Your Honor, I can respectfully tell you I don't, but also it's my understanding that for an NRCP 60B, I don't have to.
Okay, but with regard to the child support issue, which it appears it's a very reasonable issue, he's willing to pay it.
Again, this was an NRC, that was all part of my NRCP 60B. Every issue in this motion was under NRCP 60B. It was to ask you to reconsider the decree. There was no new issue before you.
Okay, well, there still should have been a meet and confer so that the parties could have alleviated this, because as we see here now, the NRCP 60 is denied, with leave though to definitely file for the motion to modify custody on the new amount, with the exception of child support being rendered for May through November at the amount that was set forth in the decree. So there's one part that is granted for the child support piece.
But I'm sorry, Your Honor, but that was part of the whole motion. So and under NRCP 60B, I don't have to do a meet and confer on that issue.
But with the interest of resolving matters, especially if you're looking to, well, with regard to the NRCP 60B motion to motion.
So the entire motion with an NRCP 60B
The motion is denied in part, but granted in part. Everything is denied with the exception of the child support from May through November at the amount that was set by the court will be granted, and that can be addressed. But everything else, we didn't get to the attorney's fees part yet. The attorney's fees part has already been briefed and addressed though. And this is where, again, this court, you guys may be seated. This matter was set for an evidentiary hearing in April. We were prepared to go forward on the financial piece. Both parties were in here. Ms. Tajbaj and Ms. Szyc were in here. You guys set the terms of your agreement on the record. After you guys set the terms of your agreement on the record, this court canvassed. It's traditional for this party to canvass the party to certify the matter pursuant to DCR 16 to let the parties know if they agree to these terms, set the terms on the record. It's a binding, non-appealable judgment. I've done that not just in this court, in this case, but in all the cases. If you're a practicing attorney, you should know that if I'm going to certify something and canvass the parties, that means it's a non-appealable binding judgment pursuant to DCR 16. The matter was brought back. The parties submitted Ms. Tajbaj submitted the decree. I reviewed the decree. I saw that there was no signature from Ms. Szyc. My staff went back to check the tapes to review it. There was an agreement regarding the attorney's fees, so the court signed it. There was an appeal that was filed. You have your right to appeal. That went up to appeal. The appeal was dismissed. The appeal was ultimately brought back down to me. I rendered my decision on custody. As far as I'm concerned, the parties agreed on attorney's fees. I don't have any jurisdiction to dive in to change your agreement. While personally, I agree that this is a sergeant case and that Ms. should be entitled to attorney's fees, and as much as I would like to grant her that, the parties made an agreement on the record here that was already submitted and signed by the court. You can go through the process with the appeal if you want again. I'll certify it as a certified non-appealable judgment or certified judgment. You can take it back to the Supreme Court, but as far as I'm concerned, I don't have the jurisdiction to come in and say, I know you guys agreed on it, but I'm going to change it because I think she should get attorney's fees, so I'm doing it my way. I can't do that. You guys had an agreement here that was put on the record. If you want, you can take it up on appeal, see what the Supreme Court says, and I'm more than happy to defer to the Supreme Court on that.
So I think that was part of the issue is that, but like we didn't agree that it was going to be a non-binding appealable. Like I didn't hear you say that. Otherwise, I would have canvassed.
I'd say that very, very clearly every time.
I understand that, Your Honor, but I didn't hear you say that.
Okay.
So like that was in my
Okay.
affidavit.
And counsel, I'm not responsible for your hearing. I'm
I
just responsible for putting the things on the record. So
also understand that, but I didn't hear you say that when you talked about it. So otherwise I would have counsel agree to it. So I apologize, but again, I should be standing. I apologize for that also. So if you are going to certify that, then I can talk to her options, but it is our position that she did ask for the sergeant fees at the very, very beginning. It was in her first pleading. It was in her second pleading.
And I will agree. She asked for that at the very first hearing. And that's why when you guys came in here and made your agreements on the record, I can't sit here and say, wait a minute, are you sure you agree to that? Because sergeant fees, you're entitled to it, because then I'm sitting as an advocate.
Sure.
And as much as I personally would agree that she should get sergeant fees, and I'd be happy to have given her attorney's fees, especially because you look at the custody decree, it was in her favor.
Yeah.
So every fiber of my being would love to give her attorney's fees, but That's not my role. My role is to listen to the parties' agreement. If you guys stand here, you guys are both competent attorneys. You guys put the terms on the record. Attorney's fees are, all the financial issues except for child support was resolved, which means all financial issues, which includes attorney's fees, are resolved. I sign it. I can't second guess when she has very competent counsel.
Well,
I
I mean,
can't
it was
second
also
guess
our
that.
position that it was that Mr. his attorney's fees, that's how it was put it on the record, and that my understanding of that is that our request for sergeant fees
So
was
you
still
can go
pending.
back and look at the tapes to see if you said that. I had my staff go back to the tapes even this morning to check. I said, just double check. Did Ms. Szyc say only his attorney's fees are
I
taken
didn't
care
put
of?
that on the record.
You
It
didn't
was-
say
it was-
that.
It was Shayla. Shayla put it on the record.
Right,
and
there
it
was
my
nothing
county will
there,
pay his
so you
attorney's
can go
fees.
back and look. There was nothing there where you're saying we're still seeking sergeant
I
fees.
didn't have to
So-
because Shayla said
Okay,
he would pay. his
And this is
attorney's
where,
fees.
again, you can go ahead and take this up, and I would love guidance from the Supreme Court.
Sure.
My position is that in as much as I would love to give her sergeant fees, because I was inclined to do that, when I have both parties standing here stating that everything is resolved except for child support, we're putting our resolution on the record. The only thing, the financial, sorry, let me say not everything. The words were all financials are resolved except for child support.
And
Everything else, don't interrupt me. I've already heard from you. You may be seated. Everything else, all the financials are resolved except for child support is what I heard counsel saying. That Shayla did say that he's gonna bear his own fees. We all know that you have, you're serving pro bono, which we wholly value. But at this point, I didn't hear you say, but we're still seeking our sergeant fees. There was nothing on the record that said that. The court looked at it, the court viewed it. The decree that was submitted is all financials are resolved except for child support. The court signed it. And then the court, that's why I canvassed the parties very clearly to let them know this is a binding, non-appealable judgment pursuant to DCR 16. And both parties agreed after being canvassed, both attorneys were present. It was submitted to me and I signed it. Now, if you're after the fact coming back and saying, no, I didn't agree to that, we really meant something else, then I can't change that. You can take it back to the Supreme Court. And if they want to say, they can look at the tapes and they can say, no, really, it should have been the other way, then I'm perfectly fine. I have no horse in this race. Because as I said, I agree that I was willing to grant a sergeant fees to your client. She was the prevailing party. It was an uneven footing. And so I couldn't agree more. But when you guys are going to come before me and state that you have agreement on the record, I'm not going to get in the way of your agreement. And I'm sure not going to say to the attorney, are you sure you want to do that? Because I was going to give your client sergeant fees. That's not my role. That would be overstepping bounds. And so at this point, I'm denying your motion for sergeant fees based upon the agreement that was rendered on the record by the parties. Okay. Now, who wants to prepare the order from today?
I do have a question, Judge. So we were talking about our counter motion for attorney's fees, and I have to get a ruling on that as well.
Yes, with regard to the attorney's fees, because Ms. Szyc, the vast majority of her request for relief was denied. And there was no EDCR 5.507 FDF that was filed, nor was there a meet and confer. I will grant a portion of the attorney's fees, but not all of the attorney's fees, because I did grant a portion of her NRCP 60B, which was as to the child support. So, and again, if I look at attorney's fees, it doesn't mean I'm even granting much, because I have to also look at both parties' financial disclosure form. So I'm going to need your client's financial disclosure form so that I can see her true financial situation. Because if I grant attorney's fees, it would be minimal considering the disparity in income between the parties.
Your Honor, just, I like to leave your courtroom with dates.
Sure.
So can I get a date by which
Yeah.
Mom needs to file her FDF? and a
FDF should be
date
filed today. I think mom graciously said she'll file it today.
By which we can submit our Brunzel memorandum of fees and costs.
Yes, well, mom will submit her FDF by today, because that should have been filed with the filing. And then the Brunzel fees, that can be filed within, what do you need, 2 weeks from there?
That's fine. I'll
Okay.
take your 2 weeks.
2 weeks, and then Ms. Zick, if you want to file a response to that, you sure can. 2 weeks to that, okay?
Sure.
All right. And
And
then I
I'll
already have
prepare
that.
the order. And
Okay.
just to clarify, Your Honor, you are now stating that it is an appealable order.
If that's what you like, yes,
Yes, please.
absolutely, yes.
Yeah.
Now, I want to make sure that we have it very clear, though, that yes, child support, you can file your motion to child support
Yes.
and everything. The only challenge I have is that if you file it back up there, then we might be stuck and not be able to go forward on anything else. So
Understood.
that's your decision, not mine.
Yeah.
Okay,
And Your Honor, I just want to note on the record, if it's going to be appealed, the objection to the court's determination on the sergeant fees. I don't
Sure.
want the court to take my, and any court to take my silence of letting your honor state your
Yeah,
position on the record
sure.
as a waiver of my right
Oh,
to
yes,
argue.
please go ahead. Go ahead.
So,
Yeah, absolutely.
I mean, I'm happy to state that now. I don't,
Sure.
you've already denied the request for fees and stated your reasoning.
Yeah.
If the Supreme Court were to disagree with your honor, I would like the opportunity to argue why we don't believe sergeant fees are appropriate.
Absolutely. Yes, it would still be open for briefing.
Thank you.
Okay, and at this point, the court is open to seeking the Supreme Court's guidance on that. At this point, I've heard the parties both make further representations on the record. And at this point, the court is going to honor the parties' representations. The court went forward and certified this matter pursuant to DCR. So for counsel to now say that she didn't know it was certified and everything of that nature, you can take that to the Supreme Court. I'm not going to change my decision at that time. Okay? All right.
Thank you.
Thank you all. Ms. Rosenblum will prepare the order. Ms. Szyc
Yes.
can sign off. Thank you all.